and consideration of legislation. Senator, would you like to take these up in the same order that we have them, or do you just want to call up the number, which one you want?
If I may call them up in an order. I'm not sure
Just tell
what
me
order
which
they're in
one.
your agenda.
Which one would you like to bring up?
2863.
2863. All right, we're D on your list, Senate Bill 2863, and I'm going to yield to Senator Sparks, who's worked very, very tirelessly on this. Appreciate your hard work. I know that you've worked way late hours and the weekend on this, and we appreciate it very much. So, Senator Sparks.
Thank you, Mr. Chairman, and thank you, members of the committee, especially at this late hour. But we do have 4 bills today that have been assigned to the Rules Committee relating to PERS legislation, and I want to give you just some basic information. I understand the sensitivity of any PERS legislation, the impact on our constituents, and I want to assure you we've worked in collaboration with the PERS board and the staff on the bills that we're presenting today. I appreciate the board members, Executive Director Higgins and the staff for working with the legislature the past several months to put together some legislation that hopefully will be beneficial to our retirement system. I, along with Senator Blunt, are appointed by the Lieutenant Governor and actually serve on the board and have been attending the board meetings, which are streamed now, recorded and available to be archived, which is very helpful for everybody. This is the reality for PERS. We have assets of $34.4 billion. We have an unfunded actuarial liability, net pension liability of $26.5 billion. That's a funded percentage of 55.9. 80% is what is considered the green line for PERS, for retirement systems. The actuaries that work for PERS make suggestions of how to get us in a better funded position. Their position is that they've shortened the amortization period. Excuse me, I'm sorry. I'm sort of focused right here. I apologize. The actuaries recommend the actuarial determined employment contribution level. We currently are moving from 17.9 to 19.9. That's percent of payroll the state, cities and counties, community colleges pay. The ADAC recommendation is 26%. That would be an additional 6% from where we're moving to. So the board has a fiduciary duty to ask us for more money. We're trying to figure this out, and it's been several years that we have not addressed it head on. There's 154,000 plus active members, 118,000 retirees and beneficiaries, and we pay out about $3.4 billion a year. I want to be very clear on these 4 bills for this committee and for my colleagues. Nothing in any of these proposed pieces of legislation changes or attempts to change any benefit to retirees, including the cost of living adjustment. There's nothing in any of this legislation that is tended to do that, nor will it do that. In 2863, I've handed you an overview. This is prepared by PERS. This is dealing with our Mississippi Deferred Compensation Program. The first part of this bill addresses Roth accounts after tax. When this was created, we have not had language that allowed for catch-up contributions. Many of you are familiar with catch-up contribution opportunities after someone exceeds the age of 50. That is the first part of this bill. It would allow that for our state employees potentially to make those catch-up contributions. The second item that is addressed in 2863 is that a qualified domestic relations order, which is a judgment or a decree for a retirement plan to pay child support, alimony, et cetera, currently is not able to be accessed, and this legislation would do that. Those are the 2 things that Senate Bill 2863 does. And Mr. Chairman, I would yield to questions as it relates to Senate Bill 2863.
Again, I just want to repeat, make sure I understood what you said, that none of these bills we're bringing up today, including this one, will affect any current employees or any current retirees. Am I correct?
That's right. There are
There will be no
benefits.
change in any of those.
That's correct, including the COLA benefits, and that is something that I have expressed as we go through this process to our friends and the staff at PERS. If anything appears to do that, for them to let us know. But that is neither the intent nor the language. And this bill and the next bill, Mr. Chairman, are actually PERS drafted and requested bills
Thank you.
and approved by the board.
And approved by the board.
Yes.
Any questions on this bill? Senator Whaley, question?
Thank you, Mr. Chairman. Thank you, Senator, for your work on this. I've listened to the description very closely and I just heard the conversation, but I wanted to reiterate, me and you, this does not affect any current retiree or current employee, correct?
It does not affect their benefits, their payments, anything of that magnitude. This allows our employees who are contributing to a deferred comp plan to make Roth style catch-up contributions via age. That's voluntary contributions. The other piece is dealing with a court order that is in place that would address rights of a spouse, former spouse, child, as it relates to support, alimony, et cetera, that they would have these deferred comp accounts that would be subject to those orders. Once again, that's not your PERS retirement. It's not your PERS stream of income. This is the deferred comp program, which is an optional contribution.
Thank you for that.
Thank you, Senator.
And also with that being said, you also stated that the PERS board that is elected, they requested this bill and they also voted to accept it, correct?
The bill was provided, the language was provided from the PERS team, and the PERS board requested this bill this year and have requested it in prior years. Thank you.
Okay, any further questions? A motion, please. That we adopt? Motion's title sufficient, do pass on Senate Bill number 2863. Any questions? All in favor say aye.
Aye.
All opposed, no. Ayes have it. That will be reported. Thank you, Senator. Next bill that of the three left, which
Number Senate Bill 2794, Mr. Chairman.
2794, please explain.
Senate Bill 2794 addresses the net pension liability. The $26.5 billion I mentioned earlier is calculated by the actuaries. That is our unfunded actuarial accumulated liability, also known as net pension liability. For several years, that amount has been provided to each of our employers, their pro rata share of that amount. They know that it is to be placed in general terms on their balance sheet because it is in fact a liability of that municipality, school district, IHL institution, state of Mississippi. That this bill would say if any employer who's a participant in the PERS system elects to leave the PERS system, they simply have to settle up the liability that is on the books relative to their employees. That is an explanation of the bill, and I would yield any questions.
Thank you, Mr. Chairman. This is on 2794, isn't that correct?
Yes, it is. Yes,
Okay.
sir.
I have a committee sub in front of me. Is that what you have in your description as well?
That is correct.
What's different in the committee sub than the original bill?
I believe the technical language, and again, both were provided by PERS, by the attorneys from PERS. I believe that they moved from the term of actuarial accumulated liability, unfunded actuarial accumulated liability to net pension liability. It's
And what's the difference?
I think it's
You know.
terminology, but it's proper terminology. If I may, I can, if you would like to hear from PERS counsel, they are here to tell us
Mr. Chairman, it's up to you.
if.
Okay. And Senator Sparks, is this something that the PERS board has also recommended as well?
That's correct.
Even the language in the committee sub?
That's correct. All of this language is from the PERS board and approved by a vote of the PERS board.
Yes, sir.
I just want to mention one thing, he's right, as far as the minor words change, that is something that I requested, technically, to be phrased that way, that particular wording change, was not in the board through version, I'll take responsibility for that, I think that.
Okay, so technically it's not, the language in the committee sub is not what the PERS board recommended today, but it's something that you've requested, just a terminology change. Do you think if I may ask him a question,
Yes, sir.
is that something you think your board would adopt the new language that you have requested in the committee sub?
It's not like.
Okay. 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 All right. Okay. Thank you, sir.
Thank you. Thank you, Senator. Any further questions? Entertain a motion at this
So
time.
at this time, Mr. Chairman, if I may, I'd like to I'd like to offer a member for a reverse repealer, just so we can get the PERS board clarification, adoption, just so we have proof of that, if we may go forward. So my amendment, if I'm recognized for an amendment, Mr. Chairman.
Well, you are, but the purpose of the amendment, let me make sure, is just to make sure that his language requested is approved by the board.
This is what the PERS board,
Absolutely.
that's the purpose of the reverse repealer, Mr. Chairman.
May I ask a
Or-
question?
Let me ask you this. What if instead of doing a reverse repealer, they tell you that it is, and if not, then you put a reverse repealer when we're on the floor?
Well, I'd rather see something in writing, to be honest with you. I've practiced
Okay.
law long enough to see,
If
to
we
make
do
sure.
something in writing then?
I-
Okay.
If I may, and from a
Yes, sir.
rules standpoint, this is a committee sub. On the floor, if you're not satisfied, Senator Barr, that we've had proper assurances, we'll call up the original bill. If that's,
No, I'm good with
Yeah.
whatever the PERS board recommends. That's not a problem.
You just
until
want it in
then,
Writing.
I
understand,
think for, you know what I'm talking
Yes,
about,
sir.
Senator Sparks. So that's my amendment, for a reverse appeal, Mr.
Okay,
Chairman.
any questions on the amendment? Senator Michelle.
Could you make it the desire that it be done prior to the bill being brought up on the floor, so we don't end up with a,
That's my intention,
Oh.
Senator Michelle, is to get something before, I think that can be accomplished before that, or brought up on the floor.
right, that would not slow up the bill that way. Thank
I
you.
don't want to kill the bill is what I'm
Thank
saying.
you.
I want,
Absolutely. You have no intention to send this bill to conference, really. That's not the purpose.
Yeah.
Okay,
and if, Mr. Chairman, if we get that clarification before Senator Sparks or this is brought up on the floor, we can remove the reverse appeal at that time.
Sure.
That's what y'all just so choose to do.
should not be a problem.
the pleasure of the committee.
All right, any other questions? We need to adopt the amendment of reverse repealer. All in favor, say aye.
Aye.
All opposed, no. The ayes have it. Reverse repealer is added. Now I guess we need a motion, final passage. House sufficient to pass committee sub. All in favor, say aye.
Aye.
All opposed, no. The ayes have it. That bill will be reported. Thank you, Senators. All right, Senator Sparks. Which one?
Senate Bill 2449.
2449. You're recognized to explain.
Thank you, Mr. Chairman. Senate Bill 2449 addresses the optional retirement program. That's a program that began in 1990 by the legislature. This is not a PERS recommended bill. PERS did recommend a amendment to the ORP section last year, but they, to my knowledge, did not make a recommendation this year. Briefly, the way ORP works is there was legislation in 1990 that allowed for some state employees to opt into this optional retirement program. And the unfortunate thing as far as the financial piece of it as it relates to PERS is that the contribution from the employee is the same amount as a PERS employee, so it's 9%. But the contribution to the defined contribution plan, deferred comp style plan, which is what an ORP is. It's not a defined benefit plan. It is a defined contribution deferred comp style plan. That money belongs to the employee. That's not a future stream of revenue. It's akin to a 401k. The rate that was paid is tied to the employer contribution rate. So as we move to 19.9 in statute, only 2.5% of the employer's contribution rate goes to PERS. The balance goes to the ORP participant. When the plan was first put together, that was a relatively low single-digit percentage. Unless we address this in legislation, as we move to 19.9, that percentage will rise to approximately 17%. So this bill purports, number one, to end ORP for new hires in the state, and they will participate in the proposed Tier 5 or whatever tier is available when they come in as it relates to employment. And the people that are currently in ORP will continue to remain in ORP, but the contribution from the employer will be capped at 9%, with the balance going into the PERS account for the unfunded actuarial liability payments, or account, I should say, not payments. This is a program that's an IHL program. I recognize that this is difficult in saying something is going to change, but with a $26.5 billion PERS liability, I cannot see continuing to tie the rate that is being paid to ORP participants to this increasing employer contribution rate. So when we get to 19.9, only 2.5% of that for an ORP participant will go to PERS. The balance will go to the ORP account for that individual. That is a brief explanation of the bill. I yield any questions.
It's my understanding that you've spoken to IHL or some of the institutions,
I've spoken to several of the institutions. Yes, Mr. Chairman.
so they're well aware of this.
They are aware.
All right, any other questions? Senator DeMar, recognize.
Thank you, Mr. Chairman. Same question, Senator Sparks. We get a committee sub before us. What's the difference between the committee sub and the original bill?
If I'm not mistaken, and I apologize if I'm incorrect on this, I think the original bill were code sections, or the anticipation was that it was code sections, but there's no, I mean, this is not a PERS quote recommended bill. This is a bill that just is taking ORP into account as about $500 million worth of payroll each year. That 2.5% is going to PERS, and we're trying to figure out legislatively the options are do nothing as it continues to climb to 19.9, to cap it where it is, cap it at some figure. We chose that figure of 9%, which is still very generous. That's a 9% match on a 9% contribution.
Chairman asked if you've spoken to several institutions within IHL.
Yes.
Is that correct?
Yes.
Did the IHL board make a recommendation on ORP?
I am not aware of any recommendation from the IHL board. I have not asked for one,
Okay.
to be clear, but I am not aware of a recommendation.
Have you spoken to Dr. Rankins, the commissioner?
I have not spoken to Dr. Rankins. Now, let me, if I may,
Yes.
this information has been requested from both ORP institutions, or institutions that have ORP employees, and from the IHL directly, because it's a little hard to track who's in ORP because they're not PERS employees. PERS does not even have the the names, if you will. They're the repository for the money. But other than receiving 2.5%, that's about the experience. So the institutions themselves know who their ORP people are. But the commissioner, I don't want to speak what the commissioner is aware of, but the request has been made on multiple occasions. Who's in ORP? How many people are in ORP during the course of this legislation?
Thank you.
Thank you.
And you're a PERS, I guess, board member, ex officio member appointed as what you indicated earlier, you and Senator Blunt. During, I guess, this topic of the PERS situation and corrections and so forth, has the topic of the ORP retirement system come up?
It has come up in conversations. I don't know that anyone, again, there was a bill last year from the PERS board that would have capped the rate and lowered the rate for any future ORP. In evaluating this, as I understand, every percent is about $5 million. So ultimately, this is a stream of revenue toward the PERS system that under the legislation will be about $50 million.
But ultimately, the PERS board didn't make a recommendation to put forth what your legislation purports to do.
I do not have an ORP PERS board recommendation this year.
Okay, thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you. Any other questions? Entertain a motion. Motion would be Donald Smith to pass committee sub. Senator Michelle, all in favor say aye. All opposed, no. No. The ayes have it. The bill will be reported. All right, Senator Sparks.
Thank you, Mr. Chairman. The final bill, I would ask on 2439 that first of all, there's an amendment. I will take that up when if you'd like me to explain
Yes,
the
sir.
bill first, and then the bill is code sections. The bill deals with all of the code sections that address how the PERS defined benefit plan functions. I regret that I do not have final language yet for this bill, but I do want to talk to you just a little bit about what the PERS board has done over the last couple of years. If I may, I have actually a copy. May I bring this up, Mr. Chairman? The PERS board has recommended at least the last 2 years for a new fifth tier. They have recognized that they believe, at least they voted, I won't say what they believe, they voted to recommend a fifth tier of legislation. This year, you have the motion in front of you, and as you see at the very beginning, to be fair, that is a motion from the December board meetings. While they've not had their subsequent meeting to approve the minutes, this is what they voted on. It's captured on video and in writing. I'll give you a moment to read the motion. May I proceed? As stated in the motion, the PERS board, and I want to be very careful how I use these words, they moved to endorse a Tier 5 proposal as stated in this motion that would be a hybrid defined contribution, defined benefit model for future employees. Once again, I'll go back to what we said earlier. This is for future not yet hired people. If somebody was hired today by a state agency, they are in Tier 4. They're in the current Tier 4 with the terms of Tier 4. This does not impact anyone who's working today, who's retired today, as far as their actual calculations, their benefits. This only affects new hires at the effective date of what this legislation would say. And their endorsement was based on a hybrid model that the staffs and the actuaries that they have reviewed and presented that is estimated and projected to have a favorable impact on the future funded status of the plan, lowering the cost of future benefits and a larger share of the employer contribution toward this unfunded actuarial accrued liability, paying off this unfunded actuarial accrued liability sooner, mitigating contribution risk, contribution rate risk, lowering future projected actuarial determined contributions, and better sustaining PERS and maintaining the fiscal integrity for existing members. This is who their motion is for, because their fiduciary duty is to these people, existing members, retirees, and beneficiaries. Those are all the people we've talked about earlier. What I would bring in this bill, and we've worked very hard to try to have the language ready for you, but it is very complex and dealing a lot with IRS code. We're trying to work with our PERS attorney team as well as the actuaries. But this is the, if you would like, Mr. Chairman, for me to explain to you briefly what the plan would be. It is a hybrid, meaning that 9% would be withdrawn from the employee's payroll as is today. The difference would be that 4% of that amount would go into a defined benefit plan, similar to what we have currently, a defined benefit being a future flow of revenue based on your years of service and your average salaries. That period of time that we would measure would be your 8 highest years. That is a difference from 4 high. It's your 8 highest consecutive years. It is an 8-year vesting period in the defined benefit. You're receiving 1% service credit for each year that you work. There is no guaranteed COLA in this defined benefit. You would be at full retirement at 62 years of age and 30 years of service. Again, you're vested at 8 years. You would be non-reduced retirement at 65 years and 8 years of service. There would be no actuarial reduction at 65. If you have 35 years of service, regardless of your age, it's your full amount you would draw, the 1% per year. That is the defined benefit piece. There is no partial lump sum option. There would be, and these are some of the things I want to make sure that I get correct. We're trying to be very careful about service credits being brought in. We want to respect the military service credit that we have offered over the years and keep that as a years of service. But we will look at how some of that information is put together. But as a general rule, it is 1% times your 8 highest consecutive years of average earned compensation. And that would be the DB portion, the defined benefit portion. The other 5% of the 9% that is taken out of your check is going into a defined contribution, similar to our deferred comp, but it's a different IRS pot, if you will. 5% would go into this as a defined contribution. There is no mandatory match from your employer, but there is the option to match. We got to bear in mind all the different employers we have, state of Mississippi, cities, counties, et cetera. On the defined contribution, that is immediate vesting, and it has portability similar to a 401k type program. So if someone is with the state and chose to leave state employment, the piece that is the defined contribution would travel with them. That is the basic premise of what we are trying to do. That, to me, and my communication, particularly with the PERS staff, has been We want to stay within the bounds of what was presented to the PERS board. There have been, their own actuaries have vetted this particular style of defined benefit, defined contribution hybrid. And they believe, and before we brought this bill to the floor, I would want a note from the actuaries that says we have met this motion, that there is a positive impact on the UAL and that we're paying off everything sooner. The state, the employer would still be tied to the same rate that we have today, which is 17.9, and it will move to 19.9. And that amount is going to pay toward the UAL, the net pension liability. They have run these models out. It does meet the criteria that's been put forth by the PERS board. And if I recall correctly, and Ray, correct me if I'm wrong, this motion passed by a vote of 9-1. So it's while there is debate and there are opinions about what the future retirement system should look like, this is something that the board, that 8 of those members are elected by current employees, retirees, PERS system people. This motion that's before you and this plan that is proposed before you that meets the guidelines of that motion was adopted 9-1 by the PERS board.
Thank you.
I think the abstention gets counted as a yay. I apologize if I took liberty there. That's all right.
Okay, Senator Sparks, go ahead.
That I'll stop there. I'll be glad to answer any questions, and I would offer an amendment at the proper time. The short title, if I may speak to that just briefly.
Yes, sir.
The short title captures the section that was inadvertently not put in this bill. The second piece of this legislation, the first is to create a 5th tier. The second piece of this legislation is, as we did with ORP, to terminate SLRP, the Supplemental Legislative Retirement Program, for future hires, in that case, future elected people that take office after the effective date of this act. In reviewing the SLRP legislation, there is actually, and I'm just going to be honest with you, gentlemen, when I ran for this seat, I didn't know this existed. I didn't know what this was. Apparently, you have 30 days to opt out of receiving this benefit, which of course, it's a benefit that you also pay for because there's a deduction from your paycheck. But if we're going to terminate ORP and we're going to move to a Tier 5, I believe that the legislature should also step up and say, we're going to be on the same situation that you are. So this would terminate SLRP for new employees. We'll continue to honor the obligation to people that are already in it, just like we're going to honor the obligation to people in Tier 4. That would be the additional code sections that I would ask to be added to the bill. And I think Ian knows which code sections I'm referring to would be the 300 sections that deal with SLRP. I would yield to any questions, Mr. Chairman.
Are there any questions by any of the members? So, Senator Michelle?
Thank you. Would you please reiterate the breakdown of the defined benefit and the defined contribution, the 2 percentages once again?
Yes, sir. 9% withdrawn from the employee's check. 4% of that goes into a defined benefit plan. 5% goes into a defined contribution plan.
Okay, thank you.
And there's no guaranteed match. There's no guaranteed COLA. But in the legislation, the expectation is that if we move in the direction that the funding allows for it in the future, we're trying to build a retirement program that is for a new generation of Mississippians. There is a lot of portability. A lot of people are not getting the gold watch anymore, working somewhere 35, 40 years. I appreciate my mom is a retiree in PERS that was a school teacher. So I understand that this is so very important to our Mississippians. As I stated earlier, $3.4 billion paid out by PERS this year. And most of those people probably still live in the state of Mississippi. But what we're trying to do is build something for the future that people have the portability piece, that we can potentially bring them in, and also build it with flexibility that our employers might be able to say, I want to put money into your defined contribution or your deferred comp account, because we know that that money is not taxed on the front end. You know, there's an IRS cap on that, but it's an opportunity that we can look at potentially even classes of employees, firefighters, police officers, teachers. People can say, hey, let's set up this defined contribution or deferred comp position that we can help them not just have a stream of income in the future, but to have the opportunity to gain significant financial security. And there's one major piece to the defined contribution, and this is why it's very important to me to get it right on the legal side, is that my consultation, I'm hearing that we want to do it obviously the right way, dealing with tax lawyers. One piece of the defined contribution or deferred comp piece that I want to make sure that is available is there is, in a 401k, there's a hardship waiver that can be received that potentially someone who has a major medical event in their life, a child, a spouse, someone of that magnitude, they could actually access their money. It's their money. They vest in that DC on day one, the first dollar they put in it. But it would be a sad circumstance if two state employees had a child that needed to go to a major medical treatment situation, and all they can look at is in the future, there's a defined benefit stream of income for me. So to me, that's one of the most important pieces of the hybrid, is that we make the DC accessible to our state employees, not just that, you know, maybe they get to a point in life and they look and they have several $1,000s that's in this account, but they could access it in a time of need.
Thanks. I wanted to ask you about, you said there's no COLA in the defined benefit. Is that to say, because we don't have the bill before us, that when you draft it, there's going to be a prohibition on a COLA, or that it's just simply not defined and will be defined later by the board?
There's not a mandatory COLA. The expectation in the legislation is that not only is it allowed, it is something that the legislature, we hope, can recommend. You got to bear in mind, we're 20, 30 years away from a tier 5 person reaching retirement. If we're able to do what we're doing and actuarially we stay sound as we expect to, my hope is that there is a COLA, but there is no language written in, which I go back to the COLA issue. In 1999, this legislature established a 3% compounded COLA, and that is a piece, a major piece of why we're $26.5 billion in debt. Now, no fault falls on employees. They didn't vote for it, but the legislature did. And my concern today is that was a time bomb that is left under my feet today and your feet and everybody in the state of Mississippi. And I hope what we're doing today allows somebody who sits in these chairs 25 years from now to not have that kind of liability, because not only did they ascribe a COLA going forward, they did it retroactively. So they gave a benefit to our hardworking state employees that we didn't pay for. And now the chickens have come home to roost financially.
I couldn't agree with you more. And what would like to see happen is make sure that doesn't occur again. What can we do? What stopgaps would you recommend to make sure that we don't end up an aggressive lawmaker a year from now, 2 years from now, 3 years from now saying, we're going to give 4% annual COLA? And it gets in the books and everybody's scared to mess with it. Every year it just keeps going and no one will address it. And they're scared to vote against it because the retirees and the people in the plan light up the phone lines. How do we stop that from happening again?
Well, and then I don't know how I can stop a future legislature from doing something. I know what we can do. We can stop the bleeding today. And I can tell you, Senator, this is about as uncomfortable as I get in a public format because I know the subject matter that I'm talking about. There isn't a more sensitive subject matter in the state of Mississippi. So I appreciate your concern. This is why we're bringing these bills forward, is to ensure, and this is a key piece that I probably haven't talked about. Part of what we're doing today is to ensure the commitments we've already made. Because it's my intention, as long as I'm in this legislature, that I will promote and vote to pay for the benefits that have already been earned. And I think each of you do that as well. But I say today, these are hard decisions that are being made for the future. And it is also to set up a prosperous retirement system. I'm quite certain that there will be those who want to say, well, we should just continue with a DB forever and a COLA forever and hope it works out. Nobody in state government or corporate America today is setting up a defined benefit plan like was set up here years ago. Most of them are being canceled. We are trying to transfer to a hybrid model that does give some assurance of a future flow of revenue through the DB piece. You're also, hopefully, things that we don't control, but the expectation is there's a Social Security piece. Then you also have the defined contribution that you have, the 5% that you've put up. And again, there's no prohibition from an employer matching you, putting some money in your DC. So that can help with your future. But those things together, I do believe we can be in a position that this is better opportunity for our future retirees, our future people that we're going to hire, but also it is more competitive and more akin to what they're seeing in corporate America. And we want to have that flexibility.
One thing we may want to look at is a consumer price index with a cap. Maybe we have a cap of 3%, but if CPI, like in several years recently, it's been less than 1%. And it would have helped the plan a lot. On the defined contribution, the 5% match, you said it's not defined. Is that going to be up to the board to decide how much they want to match to 5%?
My goal is to leave that up to each employer, because
State agency?
the employer, in other words, a city is an employer. I don't want to bind a city or a county or a K-12. I want them to have flexibility that if they are financially able to make a match, that's a perk that they can put into the program. Same way with the state agency. I want us to be able to do that. And it may be through the pure defined contribution piece, that's 5%, or it may even be in one of the conversations that I had recently with some other states. You can additionally have an optional withdrawal as a deferred compensation. And that is also pre-tax up to the limit. But I would like to see our employers do things that would incentivize people moving into deferred comp above and beyond the defined contribution and saying, maybe we'll match you if you put money into deferred comp. There's 403B that addresses educators. That's a specific type of program that's put together. So what we're hoping to do is build the framework of a defined contribution, defined benefit hybrid model that's in line with what the PERS board has endorsed, as long as it meets the criteria, but also to continue to look and see ways that we can improve, but give employers some flexibility, because the circumstances in, my little town of Belmont are different than in Biloxi, and the same way with school districts or IHLs or community colleges.
One last question, Mr. Chairman.
Yes, sir.
I kind of look at the defined contribution real similar to just our deferred comp plan in Mississippi, because we already have the right to do that, but the state doesn't match it anyway. And an employee can have quite a nest egg when they retire if they just simply put money in defined contribution. And I also look at the defined benefit as kind of a match, because if you think about it, the employer is putting money into that defined benefit plan while the employee is putting 4%. So that looks like there may be a little bit of double dip in there as far as the matching goes.
Well, ultimately, the plan sponsor, the state, is responsible for the benefits being paid. And of course, that's what we're experiencing today. And the state of Mississippi will continue to be the full faith and credit that stands behind the payments, particularly on the DB side. But again, the actuaries and the people that have been in consultation with the board and the folks that have worked together to try to bring this forward have tried to put together the best product we could that, again, I go back to the motion itself that stabilizes and sustains the PERS system for current employees, retirees, and beneficiaries, and it builds us a tool for tomorrow.
Okay, any other questions? Senator Barr?
Thank you, Mr. Chairman. First, Senator Sparks, you did a great job here. I appreciate all the hours and time you put into doing this. And so, I just greatly appreciate all the work you've done to this point. But you mentioned something about the military service credit, and I guess I missed that. I think currently you can get up to 4 years of active duty once you vested. Is that going to remain in the bill that you provide to us on the floor?
That is my intention. That's why I mentioned it specifically.
Okay.
Yes.
I just wanted to be clear. I wanted to make sure I was clear about that.
Yes, sir.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you. Senator Michelle?
One more, please. Because I've been here so long, I've seen things happen. Several years ago, we had a municipality in this state that only had about 15,000 people, and the alderman and the mayor kind of got together and went rogue, and they raised the salary of the mayor more than the city of Jackson's salary. And what can we do to prevent the good old boy system from, if you're going to give a municipality the opportunity to decide their own match, from raiding the funds of the city and pouring it into these funds? Is there some way we can put a cap on it? I hate to say that I'm scared it'll happen, but I'm scared it'll happen.
And I do think that, if you give local rule, local opportunity to do, what they're doing, they could raise the salary, I guess, but, if there should be the need for a cap put in, I think that's certainly something that can be done. I want to give them as much flexibility as I can, when I say them, employers. And in that case, the employer would be the city.
Anything else?
If I may.
Did you
an
say that
amendment.
you had an amendment possibly that you would like for us to consider?
That's correct. It just inadvertently, it's in the short title, but the code sections were not in the draft. It's the 300, it's section 2511, the 300s, which govern SLRP. That needs to be, those code sections need to be added so that can be addressed.
All right, I will ask the committee, I will offer that amendment and ask the committee any questions on that. So I'll offer that's the committee sub, I would assume, right? So, any questions? If not, all in favor say aye.
Aye.
All opposed, no. Ayes have it. All right, so that will be added to the bill. Thank you.
Thank you, Mr. Chairman.
Yeah. Well, look, I want to tell you on behalf of not just me and this committee, but the entire Senate, we all know how hard you worked on it, and we know the hours that we don't know all the hours you put in, but we can estimate the number of hours. But most of all, we really appreciate you protecting the current employees and the current retirees. I think that was very important in this legislation. One thing you didn't say, you said the effective date. You never said that, in those watching that can't see this, effective date is July the 1st, 2025.
That is correct. And again, in consultation with the folks over at PERS, I'll address that at the proper time, maybe when, if this bill comes to the floor, is that if the PERS board and the staff there expresses to me the necessity of a little bit more time needed to implement what the final legislation is, I would certainly ask that to be considered. But currently, that is the language in there. That's correct, Mr.
Thank you.
Chairman.
Now, on the committee sub, I need a motion. Senator Michelle, would you make a motion?
Our final passage by,
Yeah,
committee
committee
sub,
sub,
Senate Bill 2439. Title sufficient do pass.
committee sub do pass, yeah. House of do pass, committee sub. All in favor, say aye.
Aye.
All opposed, no.
No.
All right, the bill is passed. Now, again, I want to thank also the people at, PERS for working with us and working with the legislature. Thank you very much. I think it's important we all work together, and you, evidently you guys do as well, and we appreciate all you've done. Especially appreciate you working with, Senator Sparks, who's done a magnificent job. Any other questions? Any further business? Motion is rise report. All in favor, say aye.
Aye.
Thank you, Senator.